Hello there and welcome. This is the Disability Law Show. You've landed on the right show. 30 minutes, you will learn a lot. That much we guarantee. John Scholes here. Beside me, James Fireman, disability lawyer. Reachable anytime. Help at disabilityrights.ca or the phone number, toll free. Consultations free as well. Here it is, 1-855-821-5900. We'll repeat that through the half hour. We have phone calls, we have emails, we have all kinds of correspondence with our viewers, our radio listeners, and a main topic every week as well. This week, James, 3 reasons insurers deny mental health disability claims. This is a big one. We're going to get to that in the second segment. But litigation process. People know how it works for the law firm, know how it works for the insurance company, but how does it affect those as far as, patients or clients are involved? It's got to be pretty confusing, I guess.
Well, I think it's probably one of the biggest reasons people are hesitant to call us. Even though we give free consultations, there's no downside to it. People are just afraid of being involved in litigation, the potential for winding up in court. Well, first of all, let's start with the really good news. Long-term disability litigation virtually never winds up in court. Across Canada, there's probably about 5 or 6 cases per year. And you can look this up. There's a database called CANLI, C-A-N-L-I-I.
Really?
You can look up every case in Canada, no matter what kind of law we're talking about, since 1994. And you're going to find about 5 or 6 LTD cases on average per year. It is exceedingly rare that long-term disability cases ever wind up in front of a judge. So that's number one. If that's your concern, if you're worried that, if I call a lawyer, it means I'm going to wind up in court, virtually never. It's not impossible, but virtually never. That should not be your expectation. So what should your expectation be? If you call a lawyer, you decide to start litigation because your insurance company has cut off your benefits and you want to challenge that because you think you're still entitled. Well, generally speaking, the long-term disability process for litigation is very short and requires very little involvement from most people, especially when you compare it to other kinds of litigation. I started out doing personal injury law. And in personal injury, it would not be unusual for a case to take 4, 5, 6 years.
Wow.
Nobody would blink an eye. And you could definitely see cases that go longer than that. And certainly when you're looking at complex construction litigation or commercial litigation, those can be 10, 15 years. Long-term disability, start to finish, when someone calls me, the expectation is we will have the case resolved in 10 to 12 months. It's a little bit longer in BC and a little bit longer than that in Alberta, but it's still very, very quick, especially compared to any other kind of litigation. So what is required of you during that time? Very, very little in most cases. So the first thing that happens when we are hired is we contact the insurance company to let them know that we've been retained to bring a claim, to bring litigation, challenging the denial or termination of benefits. From that point on, the insurance company is not allowed to contact you anymore. They're not allowed to. They can't call, they can't email. All communication has to go through me or my office. They cannot contact you anymore. So that's the first thing that changes. All this fighting that you've been doing with the insurance company, gone immediately. What else is involved? Well, for about 75% of my clients, from the day they sign the retainer, the next thing that happens is we go to a mediation 10 to 12 months later and resolve the case. Nothing in between. I'll do some prep, of course, before the mediation with my client so they know what to expect, but that's nothing. That's a 1-hour meeting with me. And then we go to the mediation, which again, that's me. That's on my plate. I'm the one who's doing all the talking at the mediation. So for 75% of my clients, sign the retainer 10 to 12 months later, you are at mediation and get your case resolved with nothing in between. That doesn't mean that you're in the dark and you don't know what's happening. Certainly, anytime there's a development in your case, we're going to let you know, but you don't have to live with it on a day-to-day basis. For most people, the reason they're calling is because they don't want the stress and anxiety of having to deal with their insurance company anymore. And that's exactly what we do. We take that very seriously. You're going to know what's happening, but you're not going to have to deal with it on a day-to-day basis. Now, I said 75% of my clients are going to go right from signing the retainer to mediation 10 to 12 months later. 75% isn't 100%. So what happens to the other 25%?
Right.
Not much. So about 1 in 5, about 20% are going to have what's called an examination for discovery, or in other jurisdictions sometimes it's called questioning. It means the same thing. It's just a day that's set aside where the insurance company's lawyer would get to ask you questions for a few hours. It's done virtually in almost all cases. I would be there with you. I would prepare you for it in advance. It isn't a big deal, and it shouldn't change the timeline. So that's nothing you need to worry about. And the other possibility is what's called an IME, an independent medical evaluation, where the insurance company might hire a doctor, usually a specialist in a relevant field considering your disability, to examine you in person and provide a medical legal report to be used as evidence. This happens about 5% of the time, maybe less. It's very unusual because, one, it's really expensive. They have to pay the doctor. It's not someone who is on their payroll. It's someone who is independent that they have to pay out of their own pocket. And they don't like doing that. They don't like spending more money than they absolutely need to, especially if the result of that IME, if the report is going to support that you have a disability. And as often as not, in fact, probably more often than not, it is supportive. So it isn't something that we typically see. But if they want to do that, big deal. Everyone calling me has been to dozens, if not more, medical assessments. This is just another one, and it's not going to change the timeline either. So that's the process. It isn't anything that you need to be afraid of, and you're going to have me there walking you through it every step of the way, or whoever you hire on my team.
I think that first point you made, James, is a huge one, because I mean, you would know better. I would imagine that the fact that someone has those phone calls and emails all of a sudden stop, that's going to be, you know, I can't say 50%, but that's sure going to help the physical problems they're having, especially if it's a mental disability. Not having those phone calls, that's got to be a kiss, right?
Yeah, no, I want to be really hesitant. I don't want to suggest that starting litigation is going to be good for your mental health. That would be quite a bold claim, and I'm not saying that. But what I will tell you is, particularly for my clients who have significant mental health issues, depression and anxiety in particular, starting the litigation and not having to deal with the insurance company anymore is a really big thing for them. And almost all of them express an enormous sense of relief in just not having to deal with that anymore. I'm not going to tell you that starting litigation is good for your mental health, but there are definitely silver linings to it for sure, on top of getting your benefits restored in the end.
From the 0 to 10 to 12 months that you mentioned as far as the litigation process, is there an expectation of financial hardship for your clients? Are they worried about spending money throughout that time, or how does that whole process work generally?
Yeah, and I want to be clear. I'm not saying every case is 10 to 12 months, but I set expectations very carefully.
Sure.
And so I think it is very reasonable to go in with that expectation. It requires both sides coming to the table, but that is my experience. That's typically what happens. So I don't mind setting expectations like that for my clients. Now, what happens in the interim, in those 10 to 12 months? Well, first thing is any government assistance that you can get your hands on, whether it's EI sickness benefits, whether it's CPP disability, whether it is provincial disability benefits, you should apply for all of those, and whatever you're able to get. The worst case scenario is it's just an offset against the benefits that you're not getting anyway. So that, you know, you're no worse off for doing that, and you may be better off in the end. And then, to the extent that you can, use your savings to keep you afloat, or if you need to, borrow.
Nice. That's how it works. Got it. Guys, pocketdisabilitylawyer.ca, simple app to use. There's a bunch of drop-down menus, and basically it'll let you off at the bottom saying, yeah, you continue on, you have a case that's worth pursuing. Or you know what, you don't, all's good. It's anonymous. You can just shut down your browser and be done with it. But it's a really handy tool to use in advance to the phone call to James and his team, pocketdisabilitylawyer.ca. I mentioned the audio clips. I mentioned our radio shows. Let's get to our first call for the show, James, and see what we're talking about.
I was on LTD for 2.5, 3 years, and my insurance cut me off. I had a strong medical report from a specialist saying, you know, I still need to be off, but they just cut me off completely. And at that time, I also got a letter from my employer saying that I'm going to be considered AWOL if I don't go back. And I'm just wondering if I still have any recourse with insurance or with my employer or whatever.
This is a really good question, and it brings up a very important point, especially when it relates to Samfiru Tamarkin. Our firm does both disability and employment law, and there are issues like this that arise all the time. So what's happened here is this gentleman has been cut off benefits after 2.5, 3 years, and that's significant in and of itself. And his employer is telling him if he doesn't come back to work, then they're going to consider him absent without leave, that he is I suppose in violation of his employment contract, which is obviously a big problem, because I assume that this gentleman still believes that he is not able to work, and he has the support of his doctors and specialists saying that as well. So what do you do in this scenario? Well, for most employers, not all, but for most employers, when you start litigation, when you are actively challenging the insurance company's decision to deny, or in this case, terminate benefits, most employers are going to back off. Most employers, even though they know that the insurance company has initially made the decision to terminate benefits, they will recognize that it's an ongoing dispute, and that is theoretically in front of the courts. It's at least involved in the legal system. And until that resolves, most employers will say, okay, you're on medical leave without pay, and we'll just take a back seat until this resolves. And in most cases, they'll continue paying your benefits, your extended health and dental and so forth, which is great. Now, not all employers will do this. Some employers will still push, even though they're aware of litigation, and they could be entitled to certain information. But if they start pushing hard, we can, of course, bring in our employment team to make sure that you're going to be well protected on both ends. But the point of it is, there is something that you can do. In terms of your insurance company, it's starting litigation. And doing that, starting that litigation, is also going to, in most cases, insulate you from any action your employer might take changing your employment status.
Does the employer jump on board because they've been told by the insurance company that we're cutting off, Mr. XYZ? Is that why?
I don't want to necessarily say what any employer is basing their decision on,
right,
because each employer is different. And you have mom and pop shops who may not have any standard policy what they do in this situation, and it might be one person wearing 10 different hats, and they get a notification from the insurance company saying that you've been terminated, and they think, okay, well, I'll deal with that next week, and it goes to the bottom of a pile, and 6 months later, nothing has happened. And then there are very institutional employers, large telecoms, for example, where they may have very rigid policies. As soon as this happens, then that triggers this action from us, and so on and so forth. So what goes into that decision, that's up to each employer. All I can tell you is that in my experience, in most cases, when you start litigation to challenge the denial of LTD benefits, the employer backs off.
All right. Let's take a short break. On the other side, segment 2, get into our main topic, 3 reasons insurers deny mental health disability claims. That is coming up as we continue more of the Disability Law Show. Hang with us.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca.
And welcome back to the Disability Law Show. Thank you so much for hanging out with us through the break. Reach out to James and his team anytime. Disability lawyer, of course. Help at disabilityrights.ca through email. Phone number 1-855-821-5900. Toll free. Of course, consultations are free as well, so there's no downside to making that phone call. Maybe it's just a conversation you need to have with James and his team, but go for that at any rate here. Okay, main topic is 3 reasons insurers deny mental health disability claims. We hear this all the time. Number 1, James, insurers claim you're not following proper treatment. What do you say about that?
Yeah, we see this all the time, and not just in mental health cases, but certainly probably more often in those than in others. It's funny, I do these examinations from time to time where I get to ask questions of the claims manager from the insurance company who has made the decision to deny benefits. And part of my questioning is always about their education and their background. And not one of them that I've ever examined has ever had a background in mental health. Certainly, I've never examined a claims manager who was also a psychiatrist. Right. But even with a psychology background or some sort of counseling background, I've never seen one that has that. They might exist, but I've never seen one that has that. And yet, somehow, When we start the litigation process and I get the claims file and I see the basis for the decision, I see these opinions that you're not following proper treatment, even though in many cases they haven't consulted with a medical expert about what proper treatment is. And my client has been following exactly the recommendations of their treating doctors, therapists, psychiatrists, and so forth. But somehow the case manager knows better. That what you're doing isn't proper treatment. You should be using medication, even though your doctor say you shouldn't, or that you've had a bad reaction, or you should be trying cognitive behavioral therapy instead of whatever your therapist thinks is most appropriate, or this particular type of therapy. It drives me nuts because invariably they just don't have the expertise. And even when they will use a consultant, a medical consultant, to review the claims file, to review the medical documents and provide them their opinion, even then I find it very difficult to accept that even a psychiatrist reviewing just the materials without the opportunity to assess in person, to ask questions, to understand exactly what the person is going through or what their issues might be around taking medications. For example, if they have a family history of addiction, they may be very concerned about starting medication. These consultants don't have the opportunity to engage in any way with the insured who's making the application. And so even if they've used a consultant that says that you should be doing this treatment or that treatment, if the treating doctors and therapists say otherwise, that's who a judge is going to rely on.
Number 2, reasons why insurers deny mental health disability claims. Insurers downplay how serious your symptoms are. What do you think about that?
Yeah, I think this is particular with mental health because we're dealing with a subjective condition, and there has been a stigma about mental health for as long as people have walked the earth. It is better now than it was 30 years ago. It's better now than it was even 5 years ago. But it's still absolutely there. You're kidding yourself if you think it's not there. Yes, we are all more aware of the reality of mental health issues and how difficult it can be, and in particular, how that can impact your ability to work. But insurance companies can still use those stigmas, use their reliance on, well, it's all just in your head, and wink, wink, nudge, nudge, and expect that that is going to be valid. Because what we're talking about with mental health is almost invariably a subjective condition. So there isn't going to be that black and white proof, that x-ray that shows that you have this or not. And so the insurance company can say, well, yeah, you have this, but it doesn't seem to be serious. There's no objective evidence that that your symptoms are of a severity that would prevent you from working. But how do you really show that other than saying, this is how I'm feeling?
Mm-hmm. Third one kind of touches on that, James, and that is the insurers relying on objective evidence for arguments. Right?
Yeah, if you take a look at your long-term disability policy, with very few exceptions, I think I've seen 1 or 2 in my life, with very few exceptions, disability policies do not require objective evidence of anything. And where they do, they wouldn't even include mental health. You wouldn't be allowed to bring a mental health claim. I've seen policies that exclude mental health. They are rare. And what we're talking about on this show are the standard disability policies, in most cases, that you get as part of your group benefits through your employer. Those policies, I've never seen one where there is a requirement for you to have objective evidence. And the law says exactly that. LTD cases, as I mentioned earlier in the show, very rarely ever get to trial. But when they do, the courts have said time and time again, it does not require objective evidence. Subjective evidence is sufficient in order to ground a claim for long-term disability. There is no question about that. You're entitled to disability benefits if you have a mental health condition that is functionally preventing you from being able to do your occupation. That is the way disability policy works. So when I get a disability file, or even when I'm just meeting with a potential new client and they send me the denial letter, and the insurance company has used that language, we don't see objective evidence of your condition, I know right away I've got a really good basis to challenge the decision, and there's a decent chance that there is going to be exposure for bad faith, for potential punitive damages, because they've relied on something that is not in the policy, that they're not entitled to rely on, in order to make their decision. And if you're relying on something that's outside of the policy, how can you say that you're making your decision in good faith when you're using something that isn't part of the test to determine whether or not the person's getting benefits? That is definitionally bad faith.
We have got to take another break. We got a couple emails to roll through on the other side, but stay tuned as we continue more of the Disability Law Show.
People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca.
All right, we are back. A few minutes to go here on the Disability Law Show. Beyond the half hour, always feel free to contact James and his team. Help at disabilityrights.ca through email, and the phone call is good as well to double them up. 1-855-821-5900. There's zero charge for consultation, so that's a nice benefit to using that number anytime. Want to get to an email right here. Brian, this time round. James, he says, I work in manufacturing. I've been off for a year because of a back injury I got at home. I applied for LTD shortly after going on leave, but the insurance company denied me. I just sent in my second appeal, but I'm worried they'll deny me again. I've already been off work with no income for a year, and my doctor says my injury is still too severe to return. How can I ensure my benefits get approved? That's stressful. Man.
Well, unfortunately, Brian, that's like, how can you ensure that your benefits get approved in an appeal is like asking, how can I make sure that I win Lotto 649 this week?
Now, let me know.
You can't. No. You can't make sure that you're going to win an appeal. That's because that's not what an appeal is set up to do. So let's take a step back. What are we talking about here with an appeal? So when you apply for benefits and your claim is denied, or if it's been approved and then terminated, the insurance company will send you a letter outlining that they've denied or terminated your benefits and the reasons why they've done that. And then at the end, after they've crushed your soul and torn your heart out, they'll say, but there's good news. It's not all over yet. You still got a chance. You can do this appeal.
Spielberg ending.
There's hope. There's light at the end of the tunnel because you can do this appeal. But guess what? Your insurance company does not want to improve your benefits. If I'm breaking news to you, I'm sorry, but insurance companies are in the business to make money for their shareholders. That's what they're there to do. They're looking for any reason to deny or cut off your benefits. They do that. When they do that, they make money. So once they've found that justification, they have very little incentive to change their mind through an appeal. And the appeal itself is not an official part of the process. It just isn't. It's not anywhere in the policy itself. If you look at your LTD policy, you will not find the word appeal in there. You won't find it. It's just not part of what they're required to do. So why are they there? They're there because they would prefer that if you want an outlet to channel your frustration at your benefits being denied, that you do that using their appeal process, as opposed to calling me or another disability lawyer and starting litigation. Because once you do that, once you start litigation, the insurance company no longer has any control over the process. If you appeal, they have complete control, and the process is whatever they say it is, because it's not in the policy itself. They are literally making up the rules. They'll say, oh, well, you have to give us your information and your intention to appeal within 30 days or 60 days. Why? Because they've arbitrarily said that that's the deadline. There's nothing in the policy that says that's the deadline. They've just decided, that makes sense. That'll encourage you to do that. It has nothing to do with anything other than the insurance company wanting to avoid you starting litigation. And here's another issue for Brian. He's already been a year out of benefits. Now, it may be less than a year since he's been initially denied, but the clock is ticking. From the moment the insurance company issues the first denial, not subsequent appeal denials, the first denial, the clock starts ticking. And you have 2 years. 2 years from the date they first deny your benefits in order to start litigation. If you don't start a legal claim within 2 years of that first denial, the court is almost certainly going to say you're out of luck. You have breached the limitation period and you're not entitled to bring litigation to challenge that. And guess what? Insurance companies like to give appeals. They'll give you 6, 7, 8 appeals if you're within the 2 years. Once you're beyond that 2 years, they don't want to hear from you anymore. They don't care because there's nothing you can do about it if you go beyond that 2 years. And so, unfortunately, Brian's approach right now is playing into what the insurance company wants him to do. The solution to that is to leave the appeal garbage behind. Give us a call. If you have the support of your treating doctors, then there's almost certainly going to be a valid basis to start litigation.
Here is another tool for you to use anytime anonymously. It's called mydisabilityquestions.com. And James, we got a few minutes to go here, so we'll get Alexis's question. It says, I've been on LTD for 6 months. Lately, my insurer has been sending urgent requests for updates, demanding immediate response. If I don't reply immediately, my benefits will be cut off. This has led to increased stress and anxiety every time I must deal with this adjuster. What can I do?
I'm assuming that Alexis's disability is related to her mental health and possibly depression and anxiety, but I don't know for sure. If the insurance company has been acting this way, particularly doing so with the threat of terminating benefits if she doesn't respond immediately in a very short period of time, then that is absolutely inappropriate and could open the insurance company up to a finding of bad faith. Now, what do you do about it if you're in this situation? Because it doesn't really do you much good if theoretically down the road, if you start litigation, you might be entitled to punitive damages. If you're in this situation that Alexis is in, you don't want to be thinking about, okay, well, how do I be in a good situation for litigation, a year down the road? You want your benefits to continue because you're not working and you're not able to. You want to be able to continue getting those benefits so you can pay your mortgage and your bills. So what do you do in that scenario? Well, first and foremost, you raise it with the insurance company. You say, listen, these urgent requests aren't urgent and they're causing me increased stress and anxiety. Please stop. Say it kindly and put it in writing, everything in writing. But make sure you are very clearly asking them to stop doing that. If they don't, if they continue that, you can certainly ask that a new claims manager be assigned to your file, and they may or may not listen to that. At the same time, as this is happening, it is critical that you report the behavior of the insurance company and your reaction to that, the increase in stress and anxiety, to your doctor, to your therapist, whatever treatment providers you are seeing for your disability. They should be aware of the result of these actions of the insurance company. It should be within their file. And if appropriate, if your doctor or therapist believes that it is the case, they should write a letter to the insurance company setting out how their actions are impacting you and impacting your ability to recover and causing an increase in your symptoms and making it more difficult for you to return to work, which is what they want in the first place. And that should go in front of the insurance company. That can help. I have seen that help. It's not a guarantee that it will. Insurance companies often don't listen to reason, but that is certainly a tangible step that you can take that can make a difference. And when they get that, some insurance companies will think better of it. Either the claims manager will be smart enough to stop the behavior on their own, or it'll make its way up to a supervisor who will say, okay, we don't want that kind of exposure. Let's reassign the case managers, which unfortunately happens all the time for lots of other reasons. So it should happen where it's actually for a legitimate purpose as well.
Thank you, Alexis. We're just about out of time for this week, but continue to reach out to James and have proper correspondence. A couple different ways you can do it. First, a phone call, 1-855-821-5900. Email to go along with that is help@disabilityrights.ca. And finally, we got that question and answered it through mydisabilityquestions.com. That's completely anonymous as well. And that phone call, by the way, there is no charge for the consultation, so it's super handy. So get on top of that, and we'll see you next week right here on the Disability Law Show. Thank you so much for joining us this week.